Hey, good afternoon, everybody. We seem to have a good number of online, so I think it's time to get underway. So kia ora, tēnā koutou, tēnā koutou, tēnā koutou katoa. Welcome, everybody. I am Ben Jacobs. I'm the president of ILANZ, and in my day job, a GM in the legal team at Xero. It's great to have everybody here today for our webinar, Sanctions 101, Understanding the Basics with Ran Robinson. We'll start off a little bit about our organisation. The In-House Lawyers Association of New Zealand is a proud section of the New Zealand Law Society, and we're committed to supporting, connecting, and leading the in-house community across Aotearoa. Before I hand over to Ran, we have a little bit of housekeeping. This presentation will be approximately 45 minutes. We have 10 to 15 minutes for Q&A at the end. If you have questions, please ensure you enter them into the Zoom Q&A function, and we will pick up on those at the end when Ran has finished the bulk of her presentation. Sanctions are a challenging topic, one that affects all of our businesses, but in different ways and to different extents, making it an important but tricky area to navigate. So it's great to be able to welcome Ran, who is a fellow ILANZ committee member, but for these purposes, more importantly, a commercial and finance lawyer who first advised on sanctions in her role as a lawyer at a large global law firm in London, and is an area that she has continued to advise on since moving to New Zealand, where she's worked on sanctions-related matters in-house at previous roles with one of our big banks and with an aviation company. Ran is currently working with the Contact Energy team, and I'm delighted to hand over to her to enlighten us all on this important topic. Ran, welcome.
Thank you, Ben. Hello, everyone. I'm Ran, and I've been practicing as a lawyer for over 25 years, initially in the UK, and for the last 9 years here in New Zealand. My background, as Ben said, is in international finance and cross-border work, particularly in the aviation and shipping sectors, where you can't really get away from having to think about the impact that sanctions could have on your deals. The aim of this session is to give you, as in-house lawyers, a high-level overview of the global sanctions landscape and a practical understanding of sanctions provisions. That will hopefully give you a good foundation from which to consider how that might apply to your business or to the sector that your business operates in. That will vary enormously depending on what your business does, where it operates, the type of goods or services that might be involved, who you deal with, and where they might be based. It's an extremely wide remit, and this is a complex area. So we're only going to be able to scratch the surface in this session. But one of the messages that I'd like you to take away is that there is no one-size-fits-all approach. It has to be tailored to your specific business and to the particular risks that is exposed to. The second key message is that it's not necessarily going to be a set and forget approach. If you happen to be in one of those medium to high risk businesses or sectors in which you need to be doing more than just the bare minimum to comply, then this is likely to require constant regular monitoring, and it will help you to have good policies and processes in place to help you manage that. Some of you will be working in businesses where sanctions, risk and mitigation are well understood and embedded in normal BAU. That's most likely to be those of you that work in the banks or other financial institutions, as well as some of the bigger international trading businesses. You may well have access to sanctions experts, subscriptions to screening and compliance software to help you manage your risk and compliance obligations. For others, your exposure may well be limited to that standard form clause that started appearing in some of your contracts. You're likely to be aware of the heightened focus since Russia's war with Ukraine, but generally speaking, you don't really have to think much about it in your day-to-day work. Either way, I'm hoping that this session will give you some food for thought, and you'll either leave confident in the knowledge that you've got it reasonably covered, or perhaps it might just make you think about whether you might be needing to do more as a business to identify and manage any risk that you might be exposed to. Lastly, I'll share some practical ideas and tips on how you might go about doing that. Like I said, it's a complex topic and there's lots and lots of shades of grey. Needless to say, and I probably don't need to say it because there's lots of lawyers here, but this is a pretty, this is not, please don't take this as legal advice. It's very much an introduction to the topic, and certain concepts have been simplified so that they're easier to talk to for the purposes of this session. I'd like to start with a short exercise. So on the slide, you'll see a pretty basic sanctions clause asking a counterparty to comply with sanctions provisions. I'd like you to just spend a couple of seconds reading it and thinking about what your reaction would be if you saw this in a contract that you were asked to review. You're likely to have one of three responses. Firstly, that it looks perfectly reasonable and that you're happy to sign off on it. Secondly, you don't think that it's reasonable. You can't agree to that yourself or ask other people to sign up to that without making some changes. Or thirdly, and this is a perfectly valid response, that you don't really know what your reaction is. It's not something that you really need to worry about, and it's one of those clauses that sort of sits in the boilerplate and doesn't tend to get a lot of attention. The reason I'm asking is to help you gauge what your current personal level of understanding is. And we'll come back to this at the end of the session and see if that's changed somewhat based on what you hear over the next 45 minutes or so. So what do we mean when we talk about sanctions? Sanctions are basically the restrictions which apply to dealings with certain countries or territories, governments, groups of people, entities, individuals, or certain goods and services. The nature and extent of these variations vary hugely. Some can be very targeted and specific, while others are wide-sweeping and more general in nature. When we talk about Western sanctions, we're mainly talking about the sanctions programs of the United Nations, the US, the EU, possibly the UK and Canada, and given our location, obviously New Zealand. And for those of us working in trans-Tasman businesses, possibly also Australia. They're basically a form of economic warfare designed to achieve geopolitical ends, i.e., it's a way for a country or an organization to put pressure on another regime, another country, or another group of people to change their behavior. It's arguably a cheaper and more effective tool than going to war. That's why countries in the West like using them and why there's been a real proliferation of that use in recent years, in recent decades. That's not to say, however, that there's always consistency amongst the so-called West. Some of the more obvious reasons for why they might be imposed include to prevent terrorism, warmongering, and weapons proliferation in the form of trade and arms embargoes, to prevent the sale or supply of weapons to designated groups or individuals. They might be imposed due to human rights abuses or crime and corruption, or as a means to try and effect some kind of regime change. For example, the restrictions against the Taliban and Al-Qaeda. They might be more targeted to specific sectors. So when Russia first invaded Crimea back in 2014, the US and Europe initially imposed very targeted and limited sectoral sanctions, which were mostly aimed at limiting and cutting off access to certain types of long-term finance and economic resources. That's obviously changed since the full-scale invasion in 2022. They might be imposed against particular individuals and companies. You could have asset freezes designed to restrict access to financial assets, or travel bans to limit free movement across borders. Sanctioned people and entities usually end up being listed on particular sanctions lists. So the US has a number of these lists, the EU and the UN have consolidated lists, and New Zealand now has a list of its own. It may mean restrictions on dealing with particular assets. So, for example, a single aircraft or a ship can be designated on a sanctions list. That's particularly a hot topic right now in connection with Russia's so-called shadow fleet of vessels that are ostensibly being used to transport embargoed oil shipments. Other assets that are particularly targeted might be certain luxury goods, dual-use items, and for those items for military end use or destined for military end users. Just to expand on those points a little bit, dual-use items are certain items and they include the likes of commercial aircraft parts, drones, software and other technology, certain chemicals, specialized machinery, which can be used both for civilian and military application. When we talk about military end use, that refers to this destination or purpose of a particular item that might be exported. It goes beyond items that are clearly destined for the armed forces and what you might ordinarily expect would be caught. So it will also capture any item that might be used to support or contribute or repair or maintain anything that might be used for military or security or defense activities. It's generally construed quite widely. Similarly, military end users, they are also pretty widely defined, more so than you might imagine, to catch both traditional military entities, but also police and intelligence organizations, coast guards are caught, other end users whose activities are intended to support military end users. So for example, various other state-owned enterprises could be caught. If you've got a hospital that's treating military personnel, that might be caught. Any universities that might be supporting military projects, those will be caught. And then finally, as we've seen with the most recent moves by the Trump administration, sanctions might also be imposed purely for economic reasons. So we'll leave aside trying to analyze what the strategic position of the White House is on various global matters. But there is, as I'm sure it hasn't escaped everyone's attention, an increasing trend towards the so-called tarification of sanctions in recent months. Each program differs depending on what the purpose is and what the sanctioning entity is trying to achieve. A few points in particular that I wanted to highlight and which add further complexity when it comes to navigating this. Starting with evasion or facilitating the circumvention of sanctions, both of which are generally prohibited and often strongly frowned upon. There are extensive anti-circumvention provisions, for example, in the EU sanctions regulations, accompanied with official guidance warning EU companies not to, for example, use non-EU subsidiaries as a means of circumventing EU sanctions that would otherwise apply. The US also treats facilitation of sanctions breaches very seriously. In fact, it is unlawful under US law for anyone, anywhere, to engage in any conduct that causes others to violate US sanctions, or which has the effect of evading or avoiding US sanctions. Secondly, the existence of exemptions and licenses. Most programs will have general exemptions or licenses in place, certainly for humanitarian purposes, to allow access, for example, to medical help, basic expenses and other necessities, or in some cases, legal advice. In addition, individuals and entities can ask for specific exemptions or licenses to be granted, which allow them the ability to continue dealing with the restricted country or person or goods on certain agreed terms. Thirdly, lots of countries who are on the receiving end of Western sanctions often issue their own counter-sanctions in response. So you'll find, for example, that there are lots of examples of Western politicians and leaders who are sanctioned persons, including our very own Jacinda Ardern, who, as New Zealand's Prime Minister at the time of the Ukraine invasion, is sanctioned by Russia. Similarly, various British MPs have been sanctioned under Chinese counter-sanctions. The last point I wanted to briefly touch on is anti-boycott legislation. That makes it illegal for the citizens of one place to comply with the sanctions provisions of another country. The motivation behind that is to limit the extraterritorial reach of certain powers. The main example is an EU-wide blocking regulation that allows its various member states to take whatever measures they need to in order to protect themselves against the extraterritorial application of, generally speaking, US laws. So right now, that applies to the US's regimes against Cuba and Iran. The reason being that the EU wants to be able to protect its operators from engaging in what would otherwise be considered to be lawful international trade, but for the US provisions. Not all member states have adopted that EU blocking regulation. An example of one who has is Germany, who take their anti-boycott laws very seriously. In fact, it's illegal under German law or for Germans to participate in any kind of foreign boycott of another country. That can and does result in a divergence of approach amongst the EU. As you can imagine, that just adds to the minefield for entities who are maybe subject to different and sometimes conflicting provisions at the same time. So let's take a look now at some of the programs that are currently in place, starting with the United Nations. So the UN generally imposes sanctions in response to threats to international peace and security. There's been 31 different regimes established by the UN Security Council since 1966, with the stated aims being to support political settlement of conflicts, to promote nuclear non-proliferation, and counter-terrorism. Listed on the slide there are the countries that are currently the subject of UN sanctions in one form or another. And as you can see, they tend to be found in the more troubled regions of the world. There are currently 683 individuals on the UN consolidated list and 196 entities or other groups listed. UN sanctions are imposed by way of Security Council resolutions, which then require individual nation states to implement local legislation requiring compliance. So the responsibility falls on individual states to comply. They don't directly bind individuals or companies. That does mean, of course, that not all states implement them or implement them effectively to enforce them particularly robustly. Turning now to New Zealand. So as a UN member state, New Zealand is bound by UN Security Council decisions and have traditionally implemented the sanctions restrictions that have been issued. That was basically the only sanctions rules that New Zealand required compliance with. That all changed when Russia invaded Ukraine in 2022. It was difficult to have a coordinated UN response because members of the UN Security Council, who would usually need to work together on these things, included Russia. There were also other major countries, such as China and India, who didn't want to get involved and sanction Russia in the same way as the rest of the West did. So New Zealand's response was to issue its first set of sanctions independently from the United Nations, in tandem with other Western allies, in the form of the Russia Sanctions Act. Those actions against Russia and Russia's interests were one of the most stringent and restrictive set of coordinated sanctions issued by Western countries outside of the structure of the UN, and included effectively restricting most Russian banks and other key Russian state entities from accessing Western resources, by including the global financial system, by the cutoff from SWIFT, and access to Western airspace and technology. Severe restrictions were imposed on politically connected and state-controlled individuals and entities, i.e. most of the oligarchs, the ruling elite, and others connected with the regime. There are also separate export control restrictions that need to be followed if you are dealing with certain categories of goods or commodities. That includes restrictions on the import and export of luxury goods, such as caviar, vodka, jewels, high-value clothing, the purchase of gold, oil, and other natural resources of Russian origin, as well as a 35% blanket tariff on all imports of Russian origin goods. The New Zealand Sanctions Programme applies to all New Zealand persons and companies, regardless of where they are physically located. If you are a trans-Tasman business, then the Australian sanctions laws, which are very similar, are also likely to apply. Now, as far as I know, there's only ever been one prosecution for non-compliance with UN sanctions in New Zealand, and that was against an aviation company called Pacific Aerospace. They supplied aircraft parts to an entity knowing that those would be on-sent to repair aircraft based in North Korea. The company was found to be recklessly in breach of the sanctions law provisions, as it was generally aware of the sanctions regulations, but chose not to fully inform itself of the details. In relation to the sanctions, Russian sanctions, my understanding is that MFAT have to date taken a fairly light touch approach to enforcement, and they've wanted to focus more on outreach and encouraging compliance. Now that we're more than 3 years in, though, I think they are starting to get more serious with enforcement, with several active investigations on the go, some of which involve the police. Excuse me. Let's turn now to Europe. The EU has a similar approach to New Zealand, in that it will also generally follow UN sanctions, although sometimes it will go beyond what the UN requires and include additional measures. The EU has around 40 different programs in place, so that's obviously much more than the UN. I've listed the main additional ones on the slide there. Those programs are to further Europe's own political objectives. So you'll see on the list the likes of Russia, of course, which is heavily sanctioned in multiple ways. Belarus, also sanctioned because of its involvement in the war against Ukraine. China. There's an arms embargo relating back to the Tiananmen Square events of 1989. Turkey, a country which itself wishes to join the EU, has got asset freezes and travel restrictions for illegal drilling activities, which relate back to a decade-long frozen conflict that Turkey has with Cyprus. The EU also has general programs against the use of chemical weapons, cyber attacks, and terrorism. There are about 5,500 individuals and entities listed. By far, the biggest increase was when the Russian war started. EU sanctions are usually imposed by way of unanimous decision of the EU Council, which then requires further legislation to make them legally effective at local level. Here's where it gets tricky. Some programs, like the arms embargoes and travel bans, then need to be implemented at individual member state level through national legislation. Other programs, like the non-military trade and investment or financing assistance programs, are implemented by way of EU regulation. That applies directly to all member states. So there's no need for separate legislation to make them apply directly to companies and individuals. Enforcement, investigations, and penalties for breach are left for the relevant authorities in each member state to manage. The EU does monitor it, but given the discretion that is inbuilt into the system, approaches can and do vary. Generally speaking, EU sanctions apply within the EU or to anyone who does business with the EU, to any EU entity, even if they are outside of the EU, and on board any aircraft or vessel, which is under the jurisdiction of an EU member state. So if you are a New Zealand business with an EU connection, then you are likely to fall within the ambit of EU sanctions. If that applies, then you may need to do a separate assessment of what the relevant member state provisions are, bearing in mind that different member states implement and enforce EU-wide provisions differently. Excuse me. Lastly, but by no means least, let's move on to the states. So this is the most complex to try and summarize, as the US has the most comprehensive and wide-ranging sanctions programs, and there are a number of different agencies and government departments involved. The US in particular is very fond of using sanctions as a means to influence behavior or express displeasure. In essence, there are two types. So you get primary sanctions and secondary sanctions. Primary sanctions require a clear US connection. So they apply directly to any US persons, whether or not you are located in the US. That includes US citizens or residents, any US legal entity, including the foreign branches of US companies, to any person who is physically in the US, regardless of nationality. Certain US programs apply to non-US entities as well, who might be owned or controlled by US persons. Those are the programs which relate to Iran and Cuba. It can apply to non-US persons as well if the transaction otherwise has a US nexus. Here's where it gets wider and can refer to any kind of involvement of the US. So maybe there is a US person involved, maybe there's some US owned or controlled entities involved. You might have US origin items involved, or of course, or US dollars, which is still the world's reserve currency. A quick side note on US origin items. They include any item manufactured in the US, but also catches any non-US manufactured item that contains more than 25% US original content. Again, that makes it much broader than you might expect at first glance. US secondary sanctions, on the other hand, are extraterritorial, so no US nexus is required. These primarily target the activities of non-US persons outside of the US who engage in specified transactions with certain sanctioned countries where it is deemed to be contrary to the US national interest. So currently, that's in relation to Russia, Iran, North Korea, Hong Kong, and Syria. There's also been talk in recent weeks about potentially extending Russian secondary sanctions to India as they continue to buy lots of cheap Russian oil in breach of US primary sanctions. Generally, US sanctions programs are either comprehensive, so they're countrywide, or they're targeted, which means they're usually likely to be list-based. Comprehensive programs are in place relating to Cuba, Iran, North Korea, Syria, and the Crimea, Donetsk, and Luhansk regions of Ukraine, which prohibit virtually all transactions by US persons or within the US that involve those countries or their residents. US sanctions against Cuba are some of the most long-standing, dating back to the 60s. No other country has sanctioned Cuba in the same way. The US has also got targeted sanctions on certain specific sectors in China, mainly aimed at defense, surveillance technology, and semiconductor trades. Restrictions have, for example, been imposed on US persons supplying certain goods or services for military end use or military end users in China. Remember, we talked about how wide those definitions could be earlier. Targeted sanctions have also been imposed in response to recent cyber attacks for which the Chinese have been blamed. Now, for various domestic reasons, New Zealand did not follow suit on the China sanctions as the UK did, even though we were subject to those same attacks, partly because we have a slightly different relationship with China than the US or the UK does. It should be remembered, though, that just because New Zealand hasn't directly restricted your dealings with China, other countries may have. So you might need to be mindful of that, especially given the use of the US, given the reach of the US provisions in particular. Because there are lots of different organisations involved, enforcement varies. So OFAC, that's the Office of Foreign Assets Control, that sits within the Treasury Department and deals primarily with the financial and trade sanctions. The State Department deals with arms embargoes and secondary sanctions. BIS, which is the Bureau of Industry and Security, sits within the Department of Commerce, and they deal mainly with sanctions implemented through the Export Administration regulations. US sanctions generally cannot be taken lightly. Things may potentially be different under Trump, but for the last few decades, the US has been actively enforcing its sanctions rules by using its economic power and dominance. How they do that, if you're not a US person, is by making your life really difficult, by restricting access to the US, its people and organizations, to its financial system, and to US origin items. So you could find yourself blocked out of the US financial system and not able to clear US dollars or access any funds which might be held in US bank accounts. If your business and usual supply chain relies on dealing with US persons, US dollars, or US origin goods, that could have a fairly catastrophic impact. Your people risk being arrested if they go to the US and potentially imprisoned. One example is of a Turkish gold trader who was caught obtaining billions of dollars worth of financial aid to further the nuclear ambitions of Iran, as part of one of the biggest sanctions evasion schemes using a number of Turkish banks and supposed humanitarian aid shipments. He was caught in Florida a few years later when he took the family to Disneyland on holiday. Civil fine, you could be imposed to civil fines running up to hundreds of thousands of dollars. Another example closer to home is of Australian freight and logistics company Toll, who were fined over $6 million back in 2022 for the reckless disregard of US sanctions against North Korea, Iran, and Syria. The firm had committed almost 3,000 violations by processing millions of dollars worth of payments through the US financial system. The penalty could have been much higher, but for the fact that Toll both self-reported and OFAC didn't see the breaches as being particularly egregious. However, Toll were found not to have implemented adequate policies and the controls necessary to be able to process payments safely through the US. The worst case scenario would be getting listed yourself on one of the US sanctions lists, like OFAC's consolidated list or the SDN list, which stands for, it's a bit of a mouthful, Specially Designated Nationals and Blocked Persons list. Historically, that has happened relatively rarely, but it is a tool that's open to OFAC, and they have been increasingly willing to do that. Other practical repercussions for breach include damage to reputation, the potential time, expense, and headache of being investigated, or having your transactions blocked. You risk civil and criminal penalties in the forms of fines or criminal sentences. You may find yourself subject to breach of contract claims and or lose access to sources of finance or your own insurance cover. The other practical problem is your ability to get paid. Even if your transactions with a particular end user are not, strictly speaking, prohibited, bear in mind that various banks that might be involved at any stage of the payment process will be closely monitoring payment flows and are likely to put a block on any kind of suspicious activity. Banks are extra vigilant and in some cases have taken the commercial policy decision to just not deal with certain high-risk jurisdictions at all. All of that can take extra time and effort to get resolved, if indeed it's even capable of being resolved in the first place. So how likely are sanctions to be enforced? The good news is that countries generally don't want to punish their people, especially those who are not purposely out there breaking the rules. So the heaviest penalties are usually saved for serious and sustained breaches. Here in New Zealand, as mentioned earlier, MFAT have been mainly focused on efforts to educate and encourage compliance and regard themselves as a light touch regulator. The EU similarly advocates a fairly proportionate response. Even in the US, OFAC and BIS might start with issuing warning letters or issue a denial of licenses or export privileges. They might, or maybe a cease and desist order, all of which are civil penalties. If there's no traction with that, they may then refer it to criminal proceedings, which are then taken up by the Department of Justice. Voluntary and early disclosure of potential breaches and violations is, of course, encouraged. You're likely to get an easier ride if you do cooperate. Some of the biggest fines and penalties have been handed out are for willful evasion and circumvention of the rules. So in the 2010s, the US was very active and massive fines were handed out to lots and lots of banks and financial institutions for, in many cases, actively concealing transactions that would otherwise have breached sanctions provisions. The biggest of those fines was for 8.9 billion, and that was handed out to French bank BNP Paribas, who also had their ability to clear US dollar transactions suspended for a year. It was so serious that the French government got involved and tried to lobby for a more lenient penalty. As well as underscoring the importance the US placed on compliance at the time, it was also a pretty lucrative exercise for the regulators involved, which means that they were well-resourced and motivated to investigate and bring actions. Now, that all sounds pretty serious. And for those businesses that have been caught flouting these rules, it has led to very serious consequences. But sanctions have also led to some pretty serious consequences, even for businesses who haven't flouted any of the rules as such. They just happen to have been caught at the wrong place at the wrong time. So one really significant recent example, and I'm going back to aviation again here, are the various aircraft lessors who had leased hundreds of aircraft into Russia for years and years and found themselves on the wrong side of the war with only 28 days notice from EU authorities to stop leasing their leasing activities and get their aircraft out of Russia. The EU regulation alone affected lessors not only based in Europe, but worldwide, including the US, China, Japan, and even here in New Zealand, because many of the world's aviation companies have leasing arms based in Ireland. That resulted in more than 500 aircraft being lost to Russia as the Russian government retaliated by banning their Russian airlines from returning the assets, even though the leases had been terminated. That led to some of the biggest insurance claims and court cases in history, with millions, billions, actually multiple billions of dollars and hundreds of lawyers and barristers involved. So given all of that background, what can and should we be doing? I suggest the best place to start is to understand the risk that your business is exposed to and work out which rules apply, because not all of them will. So where do you do business? What territories are you or your people based in or have connections with? That will help you to work out what sanctions rules apply to you. Who do you do business with? So just like you might have to do with AML or KYC obligations, you should do your due diligence and have a really good understanding of who your customers and suppliers are and where they are based. That will help you to determine if you might be at risk of dealing with restricted or sanctioned people or places. What is your business supplying? Do you deal with items or services that might be restricted in some way or subject to heightened risk? Are you in the shipping industry, freight? Do you deal with luxury items, oil, aircraft or aircraft parts, IT and other technology, arms? Hopefully there's not many arms traders on this talk, but you never know. How do you do business? Do you have US or European bank accounts? Do you deal regularly with US dollars or euros? Do you or your people travel to the EU or the US regularly? Do you facilitate transactions on behalf of others, i.e. some form of broking or trading relationship where you might not necessarily know who the end user is? Do you use other brokers? And where are they based? Middlemen or middle kind of fixers based in the Middle East and Turkey in particular need to be treated with extreme caution. All of that needs to be built into your risk assessment. Who else has imposed compliance obligations on you? These are most likely to be in the form of contractual commitments. As a Kiwi company, your business may have nothing to do with the US or EU. But maybe you've inadvertently ended up in a situation where you're obliged to comply with US and EU laws because you've signed up to a contract saying that you will. Based on all those risks identified, you then need to work out what the business's risk appetite is and our tolerance. As well as helping you uncover and identify what you might need to be doing, it might have the opposite of effect in actually helping you to work out what you don't need to be doing. That could save someone an awful lot of time and energy. Generally speaking, if you are a New Zealand company dealing only with domestic customers in non-restricted goods and services, then you should be fairly confident that your risk of breaching New Zealand or indeed any other international sanctions is remote. If you are part of a global business like an international bank or financial institution, it's likely that you already have the systems, people, and policies in place to comply with that myriad of rules and regulations. And that's because your risk of being caught or affected is very high, and your risk tolerance or appetite for breach will be low. If you fall somewhere in the middle, though, then you might need to do a bit more work. Going out and getting an all-singing, all-dancing, expensive software compliance program and hiring people to operate it is unlikely to be economically justifiable for lots of organizations, especially in the current environment. But I wanted to leave you with some practical tips and suggestions for things that you could do that you might find helpful. First and foremost, it's a really good idea to put in place a sanctions policy if you don't already have one, which sets out what your risks are, how they're being treated by your board and management, and what your risk tolerance or appetite is. Review it regularly. Secondly, familiarise yourself with applicable rules and guidelines. There's lots of information available online, including on the MFAT website for New Zealand-based sanctions. The EU has a whole host of resources and guidance available, as does the US authorities. Law firms put out guidance. Some of the big global firms have access to specialist knowledge hubs, although the best bits are usually behind a paywall, but it can help to start building up your understanding. Global Sanctions is a UK-based resource run by a KC called Maya Lester and Michael O'Kane that I find really helpful for general guidance. Again, the most comprehensive bits are behind a paywall, but that could still be quite a cost-effective way of getting access to up-to-date global information if you're in a business where that might be needed. You might consider bespoke training for your staff. Because I worked in a business where sanctions were a high-risk issue, I ran a few sessions internally to increase awareness within the business and help to train up key staff and help them recognise potential red flags. I understand from MFAT that they have run training sessions for some of the bigger organisations here in New Zealand, and they're happy to be approached to roll those out to others if that would be of interest. That's obviously limited only to the New Zealand regime though, but it is an option. As with many organisations where legal resources are limited, one of the things I did was to put together a jurisdiction heat map and user guide for frontline staff to help to give them the confidence to be able to identify which particular transactions did need to be escalated to the legal team and those which were deemed low risk and could be handled as normal BAU. As with many issues, it can be tricky to try and strike the right balance, as I'm sure we'll all know, between wanting and needing the right level of engagement from the business so that genuine issues can be spotted and escalated early, with being careful not to end up in a situation where absolutely everything has to be run past the legal team and we end up being a bottleneck. You may need to get external help and advice, most likely to be in the form of external law firms here in New Zealand, although you may need to go further afield if you are exposed to international rules. So on that, my strong advice is to make sure you go to people with genuine depth of experience and understanding, as it can be time-consuming and a really costly exercise. And you want to limit situations in which you're paying for other people to learn about the system that you need help with. Another recommendation is to make sure that you keep good records. Should your business or your people ever find themselves in a situation where you might be investigated, your most valuable defense mechanism is going to be your ability to show that your business was taking reasonable steps to understand and manage your risks. If you don't have the records and paperwork in place to be able to do that, it can make life really tricky. Finally, I'd recommend you review your contracts and your approach to contracting generally and get clarity on what terms your business signs up to. Sometimes you might not have a choice with that. Your banks, for example, will have standard terms that they are obliged to have you agree to because of the risks that they are exposed to. But there'll be lots of other situations in which you may not need to be signing up to a set of rules and standards in a contract that are much higher or greater than you would ordinarily be exposed to. On the flip side, consider if you have appropriate remedies in place to get out of your contractual commitments if you do end up in a situation where your customers or counterparts fall foul of sanctions provisions. Many contracts that I see don't have sufficiently robust provisions with clear parameters and get-out clauses, and many of what the traditional provisions, such as unlawfulness clause or the force majeure provisions, may not always get you there. Now, that's a lot of information, and it probably feels a little overwhelming, especially if you're relatively new to this. So let's just distill it down to the 3 key takeaways. Firstly, it has to be a risk-based approach based on your exposure, your appetite, and your tolerance. that is not purely a question for the legal teams alone. It's a much wider discussion, and preferably one that is endorsed at exec management or ideally board level and well understood within all levels of the business. Secondly, if you are at medium or high level risk of exposure, it's a fairly constant monitoring exercise, not least because of the pace of change in global affairs. Now, sometimes that makes things worse, but sometimes things can get better when sanctions are eased or lifted. Something approaching more sort of normalized relationships can commence. That can also offer some fantastic new business opportunities that might previously have been out of bounds. There was some real optimism of that happening under Obama with Iran when things eased up a little under sanctions, although that's gone back again now under Trump. And who knows where we'll end up with Russia. It's going to be really interesting to see where New Zealand goes with its program if the EU and the US end up diverging on what to do about Ukraine, and how committed the US is to the Western coalition that put those sanctions in place in the first place under Biden. The third key takeaway is to make sure you get access to the right kind of help that is right size for your business if you need it. To finish off, let's just go back to where we started and take another look at that clause. I'd be really interested to know how many of you are now looking at this with a slightly different lens and thinking about what changes you might now need to make. Answers on a postcard, please, or just via the feedback if you'd like to share that. Thank you for listening. I hope that's been interesting and helpful.
Thank you, Rand. Interesting, helpful, slightly scary, but definitely insightful. Thank you very, very much for sharing your knowledge on this topic. We're going to move to questions. Apparently, we can't see this, but a couple of people have hands up. If you could use the Q&A function to type your question, that would be great, please. And I will relay those to Ran. And while we're waiting, giving people a chance, I'm going to ask one question. Obviously, very few, hopefully none, but very few businesses go out deliberately to subvert the regime and get around it. But with your broad experience and clearly naming no names, what sort of common mistakes do you see people make when they try to comply with sanctions regimes that you think they could try and avoid?
I think the biggest sort of takeaway is this a perception that if you don't know about it, you'll be okay. So if you don't ask the questions, maybe you'll be all right and you'll get away with it. But I think those cases that we've shown, you know, if that is seen as being reckless disregard or reckless breach because you basically haven't taken the challenge of actually going out and finding out about it, I think that is perhaps some of the biggest challenges. And then I think I think where people have genuinely tried to help, generally tried to understand it, and they can show that reasonably they have records, they have tried to do the right thing. I think the approach of authorities is generally to be helpful around that and actually be lenient on that. It's only, as I said, if it's sustained or it's really serious, it keeps going on despite the warning letters, you're likely to find yourself in really hot water.
Yes, turning a blind eye to legal compliance never seems to be a great idea. Excellent. Right, we have a couple more questions come through. First of all, first question is there a scalable way to do monitoring of existing contractual relationships? And this person says they're aware that WorldCheck has some sort of monitoring service.
I'd be really interested in that too. So I don't know what the answer to that is, I'm afraid. So yes, if, you know, I'd be interested to know what that would be as well.
Okay. And do you have any other suggestions of how to monitor contractual relationships, or is that something that just depends on the organization?
I think it depends on the organization. I think it's really difficult to give one size fits all approach here. It really does depend on the organization, the extent of its records, the extent of its contract management. Unfortunately, I think it is just a lot of, I think there's no easy answers. I think there's just a lot of hard work up front to get it right.
Yeah, thank you. Okay. So the next question is, how can organizations avoid winding up in the situation of the airplane lessors that you described earlier, where sanctions positions change? Is it just a case of hard luck, or are there some contractual strategies that you can put in place, like requiring deposits or prepayments for higher risk countries where these things may be a risk in the future when you contract?
I don't think having deposits or other forms of security in place is going to get you around a sanctions risk. So in the example of Pacific Aerospace, I think aircraft parts just shouldn't have been listed, have been sent to North Korea. It's the same with Russia now. You can't send any aircraft parts or anything like that into Russia. And so if you are getting queries from organizations that you haven't otherwise heard from, and suddenly you're getting a list of queries, and they're very keen to do business with you, really easy, money's no problem. You know, if it smells too easy, or if it smells difficult, sorry, if it smells weird, or if it looks too easy, or if it feels odd, an odd pattern of behavior that is not normal, that's a red flag, because that could be a means of people sort of actively trying to use circumvent sanction provisions and find other avenues to get access to legitimate technology. So in the example of all the aircraft that's in Russia, all these Western aircraft that are in Russia, these 500 or so aircraft, they are all running out of their useful life. They need access to parts. They need access to technology from Airbus and Boeing. And so there are lots of ways that they're trying to get those. Iran has also traditionally had lots of ways and means of using other people to get access to the products that they need. And so that is just really difficult. It's a risk-based approach, you know, and it's about maybe getting end user certificates. Lots of organizations use end user certificates. That's a good way of at least being able to show that you try to do the right thing, that you've asked the right questions, you have taken reasonable steps within your power. That's a good defense mechanism for you. It doesn't guarantee that you wouldn't be caught, but it's a good way of defending yourself.
Thank you. This is an interesting one on the tech side. One of the challenges this questioner faces is contracting for the use of pretty much all everyday software and technology hardware coming out of the US. To what extent are US companies required to impose compliance with US sanctions on their customers, for example, including BIS export regulations and restrictions on companies on the US entities list?
To what extent are they required to do that?
Yeah.
I think being a US company in a heightened risk area, they would want to do that anyway. I think they're required to make sure that their counterparts comply, and so they will. So I think you will find all those provisions as standard in US tech company documents, I would expect.
Thank you. All right, and final question for now. How would you approach the sample sanctions clause that you started and ended the talk with if you were the counterparty?
There are lots of different ways that I would approach that, depending on who the counterparty is, what business I'm working in, who I'm dealing with, and what risks I'm exposed to. There's a lot. I mean, that's the whole topic for a different session around how contractually you go about actually putting more robust provisions in place. Just having that clause alone, I mean, it's like a catch-all, but it's not really. It's very, very light touch. I know that's not really answering the question, but yeah, it's kind of almost an impossible question to answer.
Yeah, the wide range of scenarios that you presented in terms of analyzing the risk and how you have to comply, I suppose, goes to whether this is an easy or difficult thing to give for your business. Thank you. We have one question around procedural stuff. So I'll turn to that unless any more questions come in. We have a couple more minutes still if you do have more questions. But someone has asked about how to refer to this talk in CPD terms. We will be sending you an email with your CPD certificate and confirmation after the talk. So you'll get the information that you need there. Well, on that basis, I think it sounds like you've answered the questions of the panel. So thank you very much, or the attendees. Thank you very much, Ran, for sharing your learnings and insights. This has been incredibly useful. Please, to those who've joined, we're very grateful to you for taking the time. Look out for further ILANZ seminars, and please do give us ideas of anything else that you would like ILANZ to address. In the meantime, it just remains to me to say thank you once again to Ran for giving this presentation. Thank you very much.
Thanks.